Good afternoon, everyone. First of all, I know that this is an area of tremendous interest nationally. We know, especially since the Netflix documentary came out, we're getting a lot of calls. Today, what I want to make very clear, we have not conceded one way or the other. We're not saying that there was anything wrong with the original trial. We have been given evidence. We have been given a photocopy of a letter that allegedly was sent by one of the brothers to another family member talking about him being the victim of molestation. We've also got evidence that was provided by the defense, by his lawyers, that one of the members of the Menudo van alleged that he was molested by the father. None of this information has been confirmed. We are not, at this point, ready to say that we either believe or do not believe that information. But we're here to tell you that we have a moral and an ethical obligation to review what is being presented to us. I don't think there is any question in this case that the boys or the men, young men, one was 19, the other one was 21 at the time, that they murdered their parents. I think that's factual, it's been established. I think the questions that are presented to us is two simple questions. One possibility, what is being alleged by his lawyers, not by us, that there was evidence that had that evidence been presented to the jury, the outcome of this case would have been different. And second, under California law, a path to resentencing where a prosecutor can evaluate whether someone has been rehabilitated, and if so, ask the court to determine whether the person should be resentenced. If they get resentenced, there are multiple things that could happen. They could walk out based on what the court decides, or they can have the sentence given a different shape, and perhaps they will stay on, but for a longer period, lesser period of time, or they can have a new trial. Right? And those are all options, and we will evaluate all of it. In this case, again, the Menendez brothers are asking for a review through both of those vehicles. We have not decided on the outcome. We are reviewing the information.
Hey, the reaction today by the DA is what I've been saying for the last basically year and a half. A year and a half ago, we filed a writ of habeas corpus. We presented two pieces of evidence. The one was a letter from Erik to Andy Cano, which predates the killings by 8 months. The other was a declaration by Roy Rosello, who is another victim of Jose. The combination of those two, we believe, provide more than ample basis to set aside the result of the second trial. I think it's time. Their family thinks it's time. I believe that what you saw today with District Attorney Gascon was that he has taken, I think, a rather bold step in that he has said he's going to make the final decision. It's it may not be a popular decision in prosecutorial circles, but I would think that in our culture, we've come a long way in the last 10 years, maybe 15 years. I think we're at a point now where any reasonable person taking a look at this case believes they should be out. And based upon that, I'm gratified. I'm hoping that sometime before Thanksgiving, which is when the next the response is due, that the DA will either concede the habeas or join in us in asking for a resentencing.